Hello everyone, my name's Sue Hinchliffe and this is my colleague Tim Fraser. We're partners in the Arnold & Porter European Competition team. We're always looking around for interesting developments that we can share with our clients and contacts. And this topic, price relationship agreements, seemed to be one that we just couldn't afford to ignore, because it's really the focus of increased attention from both the competition authorities in the US and the EU. And we thought it would have broad appeal to companies across all industry sectors. In the US, the Department of Justice is currently challenging various most favoured nation clauses contained in hospital contracts entered into by Blue Cross. And it's also challenging MFNs contained in agreements between Apple and various publishers of ebooks. Both challenges are taking place in the federal court. In Europe, most of you will have some awareness of the fact that the European Commission is also investigating agreements in relation to ebooks, including the most favoured nation provisions contained in those agreements. And in the UK, there's a slightly less high profile, but nevertheless important ongoing investigation into agreements between the Intercontinental Group and various websites in relation to the sale of hotel rooms. In September this year, the Department of Justice and FTC held a workshop on most favoured nation clauses in the US. And later that month, the OFT published a report which had been prepared by the Lear Economic Consulting Group into price relationship agreements. And it's that report that we really want to talk to you about today. It's particularly interesting because, as well as containing a summary overview of economic literature and a case law review in relation to these types of agreements, it also identifies potential issues that can arise from them and very helpfully provides a screening device which is intended to set investigative priorities for competition authorities. Oops. So what do we mean when we're talking about a price relationship agreement? Well, the first thing to point out is that we aren't talking about resale price maintenance agreements here. Instead, the term price relation agreements has been coined by the Lear report to describe a range of different vertical agreements on pricing in which the price of a product is expressed as the function of the price of another product. And we've put four examples, or the four main examples of these types of agreements on the slide. The first is one in which the supplier says to its customer, I will match any price you get from any other supplier. That's referred to in the report as an across sellers agreement. In the second type of price relationship agreement, the supplier says, I will offer you the same price that I offer to other customers. That's termed an across customers agreement or a most favoured nation clause in the report. The third example of these types of agreements is one in which the supplier says you must set the resale price of my product at least 10 pence lower than the price of my competitor's product, and that's a straightforward reference pricing agreement. And then in the last example of a PRA, a price relationship agreement, a platform, a selling platform, says to a seller, you must sell your products on my website or my platform at a price no higher than that you sell it at on your own website or on another platform, and that's referred to as an across platform or a platform parity agreement. And with that, I'm going to turn to Tim, who's going to talk to you about the first category of agreement, across seller agreements. Tim.
Thank you, Sue. So a cross-seller agreement will usually take the form of a low price guarantee to consumers, although they also do exist further upstream in the relationship between suppliers and trade customers. So this is more of an upstream arrangement. Now, essentially, in all of these arrangements, the supplier, the seller, guarantees to the consumer or to the customer that the supplier's prices are as low or lower than other suppliers supplying equivalent or identical products. Now, it's true that where these exist at retail, the idea of an agreement in this across sellers agreement is rather stretching things because the arrangement is likely to take the form of a unilateral declaration, perhaps a declaration by a supermarket that it will sell its products at a price as low or lower than its competitors. So these types of arrangements, these guarantees, therefore used by retailers who position themselves as everyday low prices, or perhaps never knowingly undersold, or by retailers who are perceived to be more expensive when they are actually lower price suppliers, or perhaps those who have been expensive but are now trying to reposition themselves as a lower priced undertaking. Now, these are signals to consumers, and they provide information that the consumer might not otherwise easily have been able to obtain. And for that reason, they can be very useful to the consumer. And the principal signals that they provide are those which are currently on the slide at the moment. The idea that the consumer can be satisfied by these in relation to elements that they wouldn't otherwise have known. So these principal signals then all enhance consumers' interests. Now, sometimes the low price statement will be accompanied by a price match guarantee. And in this case, the consumer will be invited to produce proof that it could have obtained the product elsewhere at a lower price, in which case the supplier undertakes to compensate the consumer for the difference, or it may go actually even further and compensate the consumer for an amount greater than the difference. And a more recent variant still is where the seller itself undertakes the research and will automatically recompense the consumer where a difference arises, and that might take the form of a credit which is redeemable on the consumer's next purchase. Now, we can see the advantages of these types of arrangements for consumers on the next slide, which indicates the benefits which consumers take from across-seller agreements. So the consumer then will rely on this information, this signal provided by the retailer, in order to reduce his or her search costs, because they can rely on the signal that they are shopping in a place which is as cheap or cheaper than those of its rivals and other suppliers. Now, retailers who have high costs are unlikely to be providing low price guarantees. So naturally, the consumer will gravitate towards those retailers who do offer the guarantees and who are therefore likely to be retailers with lower costs. And this therefore removes aggregate costs from the supply chain. Both of these effects are pro-competitive. Both lead to lower costs. Now, if these effects prevail, there will be no policy reason for a competition authority to intervene, and indeed, even if they could intervene, which is something that we'll discuss later on. However, there are some elements of cross-seller agreements which have impacts which are not so benign, and this is the subject of this slide. So these non-benign features will create adverse effects for consumers and indeed for competition process itself. Now, the focus of the Lear report that Sue mentioned is to distinguish between those elements which in combination and on balance lead to a pro-competitive result and those which in combination and on balance lead to an anti-competitive one. Now, the first consideration of a non-benign effect is that the retailer, the seller, may simply be lying. It's going to be aware that its prices are not lower than its rivals, but it will subject its price match guarantee to such a level of unattainable conditions that consumers will really be unable to claim under it and indeed will be misled. Now, as the report points out, this feature is really one for consumer protection legislation rather than for competition law, but nonetheless this is an important element for practical perspective. Now, the second element, also on the slide, is that which concerns the ability of the retailer to discriminate between consumers. So in other words, between consumers who do shop around for lower prices and therefore will seek to redeem the price promise and who therefore will be given lower net prices, and those consumers who simply accept the signal but don't bother to search or to claim under it, and therefore who will have higher prices. Now this might mean, depending on the rates of redemption, that a retailer might be able to keep the price of its products higher than competitors, but still benefit from the price signal and the price guarantee. And indeed it could use this as a means to finance the redemption of the price guarantee for those consumers who do shop around. Now, price discrimination is not necessarily always an unwanted economic outcome, but the feature, I want to mention it because it does lead to a possible higher prices than might have existed in its absence, and not lower prices as one might have imagined. Now, the next feature is that if consumers accept the signals from retailers as being reliable, they're going to be less inclined to shop around for cheaper prices than they would have done in the absence of such a price guarantee. They won't test the guarantee, they'll simply believe it. Now, for this reason, sellers who engage in the low price guarantee, this PRA, may be less likely to be challenged by the prices of their competitors rather, than those who do not engage in it. And this means that price competition between suppliers will be somewhat softened, assuming, of course, the numbers of those who do challenge under the guarantee are not so great as to make any difference. Now, the irony is that this softening of competition is actually caused by these signals, caused by the guarantee. So the use of the scheme actually lowers the intensity of price competition rather than increases it, as one might have expected. Now, the other feature that might also lead to a lower intensity of price competition, or softening competition as the report calls it, is that competing suppliers may be less inclined to use price as a means of competition. So, if competitors make a lower price offer as an attempt to gain market share, if they're aware that that low price offer will be matched by the incumbent suppliers, by the others engaging in the low price guarantee, in fact, they won't gain market share. What will happen is everybody will retain their market share, but at a lower total revenue. And the likelihood of the risk of this rather irrational outcome will cause suppliers to be disinclined to engage in price competition. And that again is caused by the low price guarantee mechanism. So again, it's a worse competitive outcome than might have occurred in its absence. Now, that last feature is important, this softening of competition, but there is a rather worse outcome that's possible from a competition policy perspective, and that is that the scheme may actually serve as a means of facilitating collusion. The similarity of pricing between these sellers is highly transparent, and it may be further facilitated by price comparison websites, or indeed by consumers or customers informing the supplier that their competitors are cheaper than they are. So there is a credible threat then that a price war could be used in order to discipline suppliers who step out of line on a prior price promise, which is disciplined and policed through this low price guarantee. Now, finally, these schemes may be used as a means of deterring entry. As is normally the case, entrants who don't have any brand recognition or don't have an established customer base will often want to use a price proposition as a means of entry. But if the entrants are aware that a low price entry will be matched by the incumbent suppliers and therefore made ineffective, then entry will be deterred. And if entry is deterred, in fact, the incumbent suppliers don't actually have to go to the expense of deploying the price match guarantee, so the threat is actually both credible and costless to it. Again, a concern that's brought it about by the presence of the PRA. Now, so far we've been talking about retail arrangements, i.e. arrangements under which the consumer is informed that the seller is low or lower cost than its competitors. But as I mentioned at the beginning, these arrangements can also exist at an upstream level in relationships between upstream suppliers and intermediaries. So here we have the likely agreement will be where the customer promises to purchase either exclusively from the seller or at least to purchase a certain proportion or volume of its requirements from the supplier. But the supplier will insert an English clause into the arrangements under which the supplier agrees that should the customer be able to find the products more cheaply elsewhere, the supplier will either supply at the lower price, that's a normal English clause, or will either supply at that price or release the customer from its obligation for those volumes. That's known as a meet or release English clause. Now these can be very useful for both the supplier and the customer. The customer is released from an agreement which might no longer be beneficial to it in view of, say, falling market prices or new entry, and particularly if the contract is a long-term one where the market circumstances are hard to predict. Similarly, a supplier will be released from a contract which is no longer attractive to it because it no longer wishes to match the prices in a falling price market. So in many cases, particularly in long-term contracts in uncertain markets, these can have beneficial effects. But the problems that we discussed in relation to retail across-seller PRAs can also occur in relation to these upstream versions, and so we can't say in any one case that this is bound to be a beneficial arrangement. So that brings the question then as to whether arrangements of this nature can be governed by competition law. Can across-seller PRAs be regulated under competition law? Now, as is well known, competition law only has two instruments. It has a prohibition on anti-competitive agreements between undertakings and has a prohibition on abuse of dominance. Now, a retail level low price guarantee, even if it can be enforceable by the consumer, is not an agreement between undertakings. The consumer is not an undertaking. So in the absence of dominance of the supplier, these kinds of agreements cannot be regulated under competition law. Upstream across-seller PRAs can be, because they would normally be agreements between undertakings. And of course, both of them can be regulated if the supplier is a dominant supplier at the level of trade which is relevant. Now, because of this conundrum, we are interested in the report because it provides a step-by-step analytical approach to determining which of the PRAs not only can be, but should be governed by competition law. This is the subject of the next few slides. So should PRAs be regulated under competition law? And the first feature which the report urges us to look at are the market characteristics. And by looking at the market characteristics, we can see if the risk that the PRA might act anti-competitively is a high risk or a low one. So the unusual element of the report, as Sue mentioned in the introduction, is that it provides an analytical approach to practitioners in the counselling of clients by gathering together the higher and lower risk features which might be present in any one case, and combining them in a number of flow diagrams into an organic approach to the analysis of across-seller PRAs. When these flows are followed, it would lead to then a list of higher and lower risk features, which will eventually permit the practitioner, lawyer or economist to come to some common understanding of the assessment of these arrangements. Now, by following these steps, it will be a good indication, but it will not be conclusive. So the features on this slide then indicate the elements, the features of a market which could lead to high risk or low risk outcomes. Whether or not the market is concentrated, whether or not the participating firms have significant power, whether or not the sellers or the buyers are heterogeneous. All of these elements provide higher and lower risk elements, as indicated on the slide at the moment. And in relation to the English clause, as I mentioned on a previous slide, it's as to whether there is long-term contracting in the market or not. Now, there are three outcomes which all of these risk features are searching for: whether or not there is collusion or the softening of competition, whether there could be foreclosure, and whether there may be discrimination. Each of these outcomes then is a product of a combination of features of the market. Now, once the market is examined, the next set of characteristics concern the across-seller PRA itself. And the first elements are those which are relevant to the characteristics of an English clause, or rather a contract in which an English clause might be embedded. So, for example, if it's difficult to negotiate a long-term contract, then it may well be the case that an English clause will serve a benign purpose in allowing the parties to write the unwritten part of the agreement. Whereas, on the other hand, if long-term price changes are already provided for, perhaps in the form of a price index, it's unlikely that an English clause will serve any further purpose. Similarly, if a cross-seller and a cross-customer PRAs are offered as a bundle, that might indicate a higher risk. And if redemption costs are high, in other words, if a consumer would think that going to a higher cost seller and claiming under the guarantee would simply cost more than the likely benefit from going to a lower cost seller, if the hassle costs are high, as the report puts it, then in fact the consumer will be attracted directly to the lower cost supplier, and that re-establishes the normal form of competition. So the costs of redemption are important, as are indeed the rates of redemption. As you can see on this slide, low redemption rates, in other words, where the supplier rarely has to redeem against the guarantee, have different outcomes to high redemption rates, where the supplier is often redeeming under the guarantee. Now, there is another set of characteristics also relating to the PRA itself on this slide. These are the final ones which the report urges us to look at in determining the competitive outcomes. One is whether the promise is to beat a rival's price or merely to match a rival's price. Each of these has a different outcome for the different features of competition we're looking for. The next is whether the promise applies to the effective price of rivals, that's to say after discounts and all savings, or merely applies to rivals' list prices. Each of these have different outcomes. And finally, the meet or release version of the English clause might actually deter entry, since the incumbent will release those customers who are less profitable to it and retain those customers who are more profitable to it to supply, even at the reduced price. So although the entrant might not be aware of it, it will be collecting a group of unprofitable customers, whilst the incumbent will be retaining for itself a group of more profitable customers. So again, this is a relevant feature. Now, in using these elements, the report has developed a number of screening devices. And the screening device for across-seller PRAs is divided into two. The first is where the seller providing the PRA is dominant, and the second where it's not dominant. Now, in the case of dominant suppliers, the screen is for the likelihood of foreclosure and for the presence of countervailing efficiencies that might excuse any such foreclosure. In the case of non-dominant suppliers, the screening device is for the likely softening of competition or indeed for the presence of collusion. And the sub-bullet points which are apparent on the slide at the moment is the order and the characteristics which the screening device will look for. Now, I'm going to show you on the next slide half a diagram from the report half because it's too big to get onto one screen, to show you how this actually works. Now, I apologise for this because even though I chopped this diagram in half, it's still rather challenging on the eye side. But if you can see it from where you're sitting, you can see that you should begin the analysis at the top of the slide, the top of the diagram. Now, the diagram, the market structure is this first question. And the highest risk market structure, the one which is depicted by the large red rectangle, is one where the market is very concentrated and the PRA is adopted by a dominant undertaking or by dominant undertakings. The moderate risk market, the one depicted by the orange rectangle, is where the market is either very or moderately concentrated, but the undertaking or the undertakings which adopt the PRA are not dominant. And then finally, the lowest risk market is where the market is not concentrated at all, and only one or a few undertakings adopt the PRA, none of whom have a dominant position. Now you can see that each of the red and the yellow boxes, the orange box, contains a number of different flows relating to things like market coverage, likelihood of entry, search costs, etc. And the final outcome from each of these flows is usually a further set of risk factors for the practitioner to consider. And some of these factors enhance and some of these moderate the risk. Before going on to that, just let me show you the other half, the other third of the diagram. Sorry, we had to chop it off in the middle like this. This simply deals with outcomes relating to price discrimination and the usefulness to consumers of low price signals provided by the seller. Now, it is a very complex diagram to look at for the first time, but having regard to the context in which it's placed, in other words, the risk features which I indicated on earlier slides, I think it can be operated. Let me just finally give you an example of the risk table that it takes you to. This is the outcome of one flow, just as by way of example. You might be disappointed to see in the bottom right-hand corner that it's suggesting going to a further set of diagrams and a further set of tables. So this is very highly complex, but then it is dealing with highly complex matters. But what it does provide is a common approach to assessing risk. That's to say, common to the competition authority, to the undertaking and to the undertaking's advisors. So that although it's an unusual feature, we think it could be a useful one, at least to consider in providing advice to your business clients, either internally or externally. And with that, let me pass back to Susan.
Well, I'm going to talk to you about the category of PRAs referred to as cross-customers PRAs that are also more commonly referred to as most favoured nation clauses, MFNs, or most favoured customer clauses, MFCCs. Now, for the purpose of this discussion, I'm going to call them MFNs, in part because I find the concept of a cross-customers PRAs to be a bit of a tongue twister. In any event, these agreements generally take the form of a contractual obligation on the supplier to offer a customer the best price that he offers to any other customer over a specified period of time. They're most commonly found in agreements between input suppliers and downstream firms. We don't see any examples in the report of these being the type of promises that are made to consumers, unlike the type of agreements that Tim's been talking about. The obligation on the seller can either be contemporaneous or it can be retroactive. If it's contemporaneous, the price that's taken into account are only those that are available at the time the purchase is made. If they're retroactive, the relevant prices includes all those prices that will be available over a predefined period of time and require the seller to refund the buyer for purchases made in the past at a higher price. The report conceptualises an MFN as a penalty imposed on the supplier in the event that it decides to lower the price of the product to another customer. The value of the penalty depends on the level of discount it offers to the other buyer, on the volume of products covered by the MFN, and also on the probability that the buyer will actually benefit from the MFN. And what we mean by that is that whilst some MFNs may impose an automatic obligation on the supplier to refund the buyer, others do not. Others sometimes require that the buyer may actually have to make a claim against the seller in relation to the MFN. And whether or not he does that, and whether or not he's able to do that because of features of the market, or indeed his own tolerance of hassle factors, or his own awareness of other pricing, is another criteria in the equation in calculating the penalty. So what harm do MFNs do? Well, the report, I think, and this is probably just my sense of the report, is rather more generous to MFNs than it is to the type of cross-seller agreements that Tim was introducing you to. The report identifies 4 to 5 different theories of harm in relation to MFNs, and these are set out on the slide. The first 3, downstream foreclosure, softening of competition and collusion between suppliers, are the ones that I think have mostly made an appearance in the case law, both in the US and the EU. But we shouldn't ignore the last 2, which are drawn largely, I think, from academic studies. The first theory of harm, downstream foreclosure, is a reflection of the idea that the use of these clauses may prevent smaller companies who need a cost advantage to attract initial customers and then to reach a minimum efficient scale from entering the market. This has the potential to harm consumers because they're deprived of access to potentially more efficient sellers. That raises production costs and thereby final prices. The theory of harm in relation to the softening of competition, I think, is rather complex and is described in great detail in the report. But essentially, the theory is more robust in relation to retroactive MFNs. Under that theory, competitors of the supplier offering the MFNs are able to anticipate that that supplier is unlikely to want to reduce his prices over time because of the level of penalty that he will have to incur in doing so. And that acts as a disincentive on the first supplier from lowering his prices as well. Contemporaneous MFNs don't seem to instinctively have that effect, but they may be more likely to have that effect where they're more prevalent in the market. And certainly there's some suggestion that the more contemporaneous MFNs you have in the market, the more harm is likely to be caused. In relation to collusion, I think the report somewhat sits on the fence. It makes the comment that these MFNs may reduce the incentive for a seller to deviate from an agreement with other sellers by offering lower prices and selective discounts. But the report also balances that with a reflection on the fact that actually penalising deviations may be more difficult because of the inability to cut prices selectively, and the fact that sellers would have to reduce the prices to all buyers by way of punishment of another seller. As I mentioned, those are the 3 that seem to crop up most in the case law, but the report also refers to 2 other theories of harm. It recognises that the use of an MFN may of itself amount to discrimination between customers, insofar as some customers benefit from the MFN whilst others do not, but also says that an MFN given to lots of customers may also lead to discrimination, where there are a diverse range of customers with different abilities to actually benefit from the MFN. Finally, there's a theory of harm in relation to the fact that these clauses can sometimes strengthen the bargaining position of a supplier. The theory is that this is most likely to arise where you've got a monopolist in the upstream level, the supplier level, where the buyer might be expected to pay a monopoly price, but he doesn't want to do that, and he's patient and he hangs out for the supplier to reduce prices over time. By entering into an MFN, the supplier essentially signals to the market that he will not be reducing prices, and it induces a broader range of customers to pay monopoly prices. The report acknowledges that MFNs have the potential to harm competition but also generate efficiencies. And they say that because of this, it's difficult to anticipate or to reach a conclusion on whether MFNs are actually good or bad for consumers. In terms of efficiencies, they focus on 2 efficiencies but identify 3. In relation to the first efficiency included on the slide, the point is that buyers that have to make specific investments in the products that they're purchasing, for example, input specific machinery, may be in a bad bargaining position after they've made that investment vis-à-vis the seller. And the MFN gives them some protection against that bargaining position and allows them to have confidence that their investment, that they will be able to get a return on their investment. Somewhat similar efficiency relates to the investments potentially made by suppliers, where, for example, the supplier has to incur significant fixed costs in the production of the product in question, and where he faces customers with a different willingness to pay. In those circumstances, and without the MFN, it would be expected that he will be able to charge higher prices to those groups of customers who are willing to pay, and then reduce prices over time to other customers who are less willing to pay. If the first group of customers are patient and wait for the lower prices, then the supplier is forced to offer those lower prices earlier on in the sales process, and this may not allow it to cover all of its investment costs. So the MFN essentially allows the supplier to offer a higher price at the beginning of the sales process and hence cover its costs. Finally, the report makes a brief mention of the fact that there's been some suggestion that an MFN may create efficiencies by allowing the supplier to signal the quality of its products to the market, but that is not discussed in any detail in the report, and I think it's not an efficiency that's been well argued in the case law. So, as referred to by Tim, as well as reviewing the literature on theories of harm in relation to various PRAs, the report discusses policy choices and also sets out these screening devices in relation to certain categories of PRAs. It identifies whether or not PRAs should be regulated, and in doing so, it actually doesn't really distinguish a great deal between the across-seller PRAs and the across-customer PRAs. Thus, the criteria that Tim set out in relation to whether or not these types of agreements should be regulated are broadly similar for both types of agreements. The only comment that's made in the report specific to MFNs is that the report suggests that retroactive MFNs are likely to be more harmful to competition than contemporaneous MFNs, which is I guess, based on what we've already discussing, not particularly surprising. As I mentioned, we have lovely diagrams in terms of screening devices for MFNs as well as for the agreements that Tim was talking about. And we've made the same attempt in the following slides to split out those diagrams into something that may hopefully be of some help to you. But I thought it might be useful to just boil down in summary terms the outcome of that screening device and to try and identify for each of the theories of harm what the key indicators of concern will be based on those diagrams and that flow chart. So in relation to downstream foreclosure, if you follow the screening device through, you reach the conclusion that downstream foreclosure is primarily a risk where the supplier market is concentrated, and where the downstream buyer market is also concentrated and there's a buyer with a dominant position in the market, or alternatively where the MFN is offered by a vertically integrated supplier with a dominant position upstream. The risk of downstream foreclosure is greatest, however, where the buyers have no equally efficient sources of supply other than those covered by an MFN. In relation to the theory of harm surrounding softening of competition and collusion, if you follow the screening device through, the place you get to is that there's a modest risk of softening of competition or collusion where the supplier market is concentrated and where you have either a contemporaneous MFN that's widely adopted or an MFN that's retroactive but not widely adopted. The screening device also suggests that you might actually have a modest risk of softening of competition, even in a fragmented supplier market, but a higher level of homogeneity amongst buyers. The more serious risk of softening of competition and collusion arises where you have many of the key features, so a concentrated supplier market, retroactive MFN, which is widely applied. Finally, the screening device covers other theories of harm, including discrimination and increasing the bargaining power of the supplier. And those issues are more likely to arise where you've got a high diversity amongst firms, and particularly where products are homogeneous. So let me just show you quickly, and we won't dwell on this because we have some other topics to cover, on the screening device for these across customer PRAs, the MFNs, which unfortunately we also had to split into 2 slides because they were not capable of splitting into 1 slide. And finally, I've given you an example similar to the further checks for across suppliers agreements that we also have for across customer agreements. And with that, I wanted to move on to a slightly different topic, but still obviously related to MFNs, and talk about some recent cases, high-profile cases that are going on currently in Europe in relation to MFNs. These cases are actually not discussed in the Lear report, but I think that they're really important because they're quite different from the types of MFNs in the Lear report. Firstly, because they cover more than wholesale pricing. By that I mean they're not just an agreement in relation to the price that the seller offers to the buyer. And secondly, they're contained in the context of agency agreements, which creates quite a different dynamic for the analysis. In the ebook case, the European Commission is investigating potential competition concerns arising out of the fact that a number of European publishers changed their distribution agreements in relation to ebooks with Apple from a distribution model to an agency model pretty much all at the same time. The important point from the discussion on pricing perspective is that the agency model allows publishers to set the retail price of ebooks and therefore prevents Apple from doing its own pricing, and indeed prevents other online ebook sellers with whom it has the same agency arrangements from also setting their own prices. Importantly, from the discussion on MFNs, these agreements also contain MFN clauses which the European Commission has described as unusual, and that's because they cover not only wholesale prices but also cover retail prices. So the MFN, under the MFN, the publisher agrees that they won't set the retail price of a book sold on the Apple portal at a lower level through a different portal. There's also an MFN, interestingly, in relation to the type of business arrangement that Apple has with the publisher, i.e. in relation to the agency model, whereby the agreement that it has with Apple depends on the agreement that it has with other sellers of ebooks. And we can only assume, if it follows the model of a standard MFN clause, that this clause says that if the publishers move from an agency agreement with Apple, if they move from an agency agreement to a distribution model with another reseller of ebooks, then they will also do the same in relation to Apple. So why does the fact that these MFNs go beyond the standard MFN in relation to wholesale prices and are included in an agency agreements matter? Well, we don't really know yet what the European Commission thinks about this, but I think there are a couple of comments that can also already be made. The first is that the agency arrangements are the primary means by which the publishers are by which prices are being set. They allow the publishers essentially to have a system of resale price maintenance. However, there's a potential for these agency agreements to be found to be non-genuine agency agreements as defined by the Commission. As some of you may know, the Commission has a very narrow definition of agency agreements, and there are 2 points that cast doubt, or 2 features of these arrangements that I think cast doubt on whether the definition has been correctly applied here. In particular, the definition requires that the agent should not have to have made any significant product-specific investments in relation to its agency activities. And without knowing any details, I imagine that Apple must have made some fairly significant product-specific investments in relation to the sale of e-books. And secondly, it's been observed by some commentators, including by members of staff from the OFT, that the imposition of an MFN on the publishers by Apple itself suggests the type of relationship which is not consistent with true agency. Interestingly, I think it's arguable that if you took away the agency arrangements, you might actually not have any need for the MFNs in the agreement. But that, I think, remains to be seen how that will play out if these agreements are altered. But assuming that the agency model is valid, then the question is, what's causing the competitive harm? Or at least the question is, what competitive harm are the MFNs causing? The traditional MFN in relation to wholesale prices can't affect retail prices because these are already determined by the publishers. Therefore, it seems to me that the only possible theory of harm must relate to foreclosure of the market to other potentially more efficient retailers of e-books who might find it difficult to enter the market if they can't offer publishers cheaper wholesale prices to attract content in order to attract customers. However, I think this may well be counterbalanced by an efficiencies argument based on the need for the MFN to protect the investment that's been made by companies such as Apple. The retail MFN has a questionable impact because in an agency model you might well expect to see uniform prices across an agency network, and therefore it's questionable as to whether that provision actually changes the pricing conduct of the publishers at all. The business arrangement MFN is particularly novel and is arguably designed to ensure that should the publishers move to a more free distribution model for another e-book seller, then Apple will be able to go to that model too. It might be argued that the existence of the MFN somehow acts as a disincentive for publishers to do that because of the penalty that it would suffer by having to allow Apple and potentially other retailers to also move to that model. But I think that has to be balanced against what the counterfactual will be. And there seems to me that in that context, there's no evidence that there will be any incentive or desire on the part of publishers to move to a more free pricing model. And that's exhibited by the fact that they have a preference for agency. The commitments that have been offered by Apple and the publishers to remedy the concerns identified by the European Commission about these arrangements really focus more, I think, on removal of the MFNs rather than terminating agency agreements, although they do allow for termination of the agency agreements. That rather suggests that if you're looking at the question of, well, what's causing more harm here, the agency or the MFNs, that the idea is that the intention is that actually that the MFNs are causing more harm than the agency. But that may be more of a reflection of the views of the parties giving the commitments rather than a reflection of the Commission's views. And that remains to be seen in the way in which the Commission responds to those commitments. I haven't talked in any great detail about the hotel booking case which the OFT is looking at, but it largely raises the same issues about agency agreements and the extent to which an MFN in an agency context harms competition. As I mentioned earlier, I think the OFT is more focused on the impact of the agency agreements than the commissioners obviously seem to be, and therefore I'm hopeful that as that case moves forward, we may get more clarity on what agency means in an online selling context. At the start of the presentation, we gave you 4 examples of PRAs. And Tim's talked about the first one, cross-seller agreements. I've talked about MFNs, the second category of agreements. The third category we referred to was reference pricing. Now, we weren't intending to discuss reference pricing in any detail in this presentation, mainly because it's quite an extensive topic and we could probably take an hour discussing that on its own. As some of you may know, the OFT ran a long case in relation to reference pricing, in relation to the retailing of cigarettes in the UK. It suffered a great defeat in that case, but the defeat related more to the value of the evidence that it adduced rather than to the theory of harm. So if any of you are particularly interested in reference pricing, we believe that the OFT's decision in that case is still an interesting examination of the theory of harm in relation to reference pricing, and we believe that the theory holds good, even if on the evidence they weren't able to prove the theory. But we did want to spend just 2 minutes talking about the fourth category of agreement that's referred to in the report, and these are cross-platform PRAs, or platform parity agreements. And these are rather interesting agreements because they seem to be somewhat novel and becoming more prevalent in an online trading environment, although the report does acknowledge that they do exist in between other retail platforms, for example, shopping centres and other retail outlets. Essentially, under these agreements, the seller agrees with one platform that he won't charge a price for his products on that platform that is higher than he charges on any other platform, including his own. The impact is on the price that the seller sells his product at, not on the price charged by the platform for the services that the platform provides to the seller. This is an important area, I think, but it's interesting that the report doesn't reach any policy conclusions or provide any screening device for these kinds of agreements. And that's essentially because there's a real dearth of academic literature on these agreements and apparently no case law on them. And therefore the report simply makes some general observations about what they acknowledge to be really rather a complex theory of harm. Now, most of those observations involve competition between platforms. In the first instance, it seems that such agreements can limit new entrants if they're not able to offer sellers the opportunity to offer consumers lower prices. Although I'm not sure whether that's enough, because it seems to me that a new entrant could still benefit from reducing its prices to sellers or its fees to sellers to incentivise their use of the platform by allowing them to benefit from increased margins. However, that view is subject to the second observation made in the report, which is there may be reduced competition between platforms because there's little incentive for them to reduce their fees or to offer novel fee structures if the platform can't benefit from doing that by increasing the volumes of sales on its website or the total fees it gets, because the seller is not able to pass that fee reduction on to buyers in the form of cheaper prices. Collusion between platforms, it seems, may arise because incentives to deviate are low, and deviation may be readily discovered because sellers may frequently complain to platforms about the fees that they're having to pay. Finally, the report considers that such agreement might affect actually competition between sellers, as they cannot discriminate between customers, and also the fact that there are fewer price points because pricing has to be fairly uniform makes monitoring of deviation from collusion easier.
Thank you very much, Sue. We've had a number of comments online whilst we've been talking. My favourite one is the one which refers to bloated bureaucratic authorities, which is a phrase not used in the Lear report, but I very much like the comment you made, so thank you very much for that one. We think the report and the case law, the developing case law which Sue mentions, do contain the seeds of very important discussion on the development of theory towards price, both at a consumer level and upstream. And we hope that to be able to have further webinars on this interesting topic, but we hope we've at least whetted your appetite for further study in relation to this. So thank you very much indeed for attending. And other suppliers supplying equivalent or identical products. Now, it's true that where these exist at retail, the idea of an agreement in this across sellers agreement is rather stretching things because the arrangement is likely to take the form of a unilateral declaration, perhaps a declaration by a supermarket that it will sell its products at a price as low or lower than its competitors. So these types of arrangements, these guarantees, therefore used by retailers who position themselves as everyday low prices, or perhaps never knowingly undersold, or by retailers who are perceived to be more expensive when they are actually lower price suppliers, or perhaps those who have been expensive but are now trying to reposition themselves as a lower priced undertaking. Now, these are signals to consumers, and they provide information that the consumer might not otherwise easily have been able to obtain. And for that reason, they can be very useful to the consumer. And the principal signals that they provide are those which are currently on the slide at the moment. The idea that the consumer can be satisfied by these in relation to elements that they wouldn't otherwise have known. So these principal signals then all enhance consumers' interests. Now, sometimes the low price statement will be accompanied by a price match guarantee. And in this case, the consumer will be invited to produce proof that it could have obtained the product elsewhere at a lower price, in which case the supplier undertakes to compensate the consumer for the difference, or it may go actually even further and compensate the consumer for an amount greater than the difference. And a more recent variant still is where the seller itself undertakes the research and will automatically recompense the consumer where a difference arises, and that might take the form of a credit which is redeemable on the consumer's next purchase. Now, we can see the advantages of these types of arrangements for consumers on the next slide, which indicates the benefits which consumers take from across-seller agreements. So the consumer then will rely on this information, this signal provided by the retailer, in order to reduce his or her search costs, because they can rely on the signal that they are shopping in a place which is as cheap or
that I offer to other customers. That's termed an across customers agreement, or a most favoured nation clause in the report. The third example of these types of agreements is one in which the supplier says, you must set the resale price of my product at least 10 pence lower than the price of my competitor's product, and that's a straightforward reference pricing agreement. And then in the last example of a PRA, a price relationship agreement, a platform, a selling platform, says to a seller, you must sell your products on my website or my platform at a price no higher than that you sell it at on your own website or on another platform, and that's referred to as an across-platform or a platform parity agreement. And with that, I'm going to turn to Tim, who's going to talk to you about the first category of agreement, across-seller agreements. Tim.
Thank you, Sue. So a cross-seller agreement will usually take the form of a low price guarantee to consumers, or they also do exist further upstream in the relationship between suppliers and trade customers. So this is more of an upstream arrangement. Now, essentially, in all of these arrangements, the supplier, the seller, guarantees to the consumer or to the customer that the supplier's prices are as low or lower than.
And later that month, the OFT published a report which had been prepared by the Lear Economic Consulting Group into price relationship agreements. And it's that report that we really want to talk to you about today. It's particularly interesting because, as well as containing a summary overview of economic literature and a case law review in relation to these types of agreements, it also identifies potential issues that can arise from them, and very helpfully provides a screening device which is intended to set investigative priorities for competition authorities. Oops. So what do we mean when we're talking about a price relationship agreement? Well, the first thing to point out is that we aren't talking about resale price maintenance agreements here. Instead, the term price relation agreements has been coined by the Lear report to describe a range of different vertical agreements on pricing in which the price of a product is expressed as the function of the price of another product. And we've put four examples, or the four main examples of these types of agreements on the slide. The first is one in which the supplier says, to its customer, I will match any price you get from any other supplier. That's referred to in the report as an across sellers agreement. In the second type of price relationship agreement, the supplier says, I will offer you the same price. Hello everyone, my name's Sue Hinchliffe and this is my colleague Tim Fraser. We're partners in the Arnold & Porter European competition team. We're always looking around for interesting developments that we can share with our clients and contacts. And this topic, price relationship agreements, seemed to be one that we just couldn't afford to ignore, because it's really the focus of increased attention from both the competition authorities in the US and the EU. And we thought it would have broad appeal to companies across all industry sectors. In the US, the Department of Justice is currently challenging various most favoured nation clauses contained in hospital contracts entered into by Blue Cross. And it's also challenging MFNs contained in agreements between Apple and various publishers of ebooks. Both challenges are taking place in the federal court. In Europe, most of you will have some awareness of the fact that the European Commission is also investigating agreements in relation to ebooks, including the most favoured nation provisions contained in those agreements. And in the UK, there's a slightly less high profile, but nevertheless important ongoing investigation into agreements between the Intercontinental Group and various websites in relation to the sale of hotel rooms. In September this year, the Department of Justice and FTC held a workshop on most favoured nation clauses in the US,